Hey everybody, this is Chad Bird. I'm one of the owners of OutsideAgents.com, and I'm really excited today to share with you some information about copyrights. I don't know if you folks understand just how important intellectual property is in today's society, but today I'm going to try to cover basically what is intellectual property, what is copyright, and what you can do to avoid getting in trouble, and what you can do to get out of trouble if something bad happens. So folks, at their heart, copyrights are tiny issues with big consequences that are really easy to avoid. Let me show you. So first of all, what is a copyright? Well, it's a type of intellectual property. Okay? Intellectual properties are basically creations of the mind, like inventions, literary art, artistic works, symbols, names, and images used in commerce. Specifically, a copyright is a subtype of intellectual property that's applied to tangible, original, creative works, including those of a digital nature. These rights provide exclusive protections to the owner, including distribution, use, repurposing, derivative works, modification, you name it, it's covered. And at the end of the day, folks, you have to have express, preferably written permission from the owner to use it. Now, why is this important? Because the average cost of a violation is $600 to $1,200. We had a guy, agent years ago at a trade show, had a stack of business cards sitting there, and he had a picture of somebody using a vending machine on a flyer, and the image on the vending machine was copyrighted. He got a letter with a demand for use of that image twice, and it explained to him that he had used it 500 times, and they could have come after him for $250,000. It was a legitimate claim. Anyway, the purpose of copyright is to prevent confusion, right, that might dilute the value of a work or brand. Okay, and remember, if we're diluting the value of a work or brand, then, especially in commercial use, somebody's going to want to get paid for that. So moving on with intellectual property businesses, there's this thing called fair use, and it's oftentimes misunderstood. It was designed so that you could make a Xerox copy of a page of a book at a library and take it with you. Okay, remember, copyright law is last century law. They really haven't caught up well to the current environment. But fair use allows us for the limited use of copyrighted material for social benefit, basically, for research, criticism, commentary, reporting, teaching, that kind of thing. Folks, fair use almost never applies to commercial use. And speaking of commercial use, you see these symbols all over the place, the CER trademark. They're not required per se, but they are highly recommended to let other people know that that work is copyrighted. At the end of the day, the bottom line is this: assume that you cannot use intellectual property until you are certain that you can. Remember, you're responsible for all the use of all intellectual property, regardless of the source. Even if it's come from outside agents or vendors, you're ultimately responsible for where it's displayed. It's kind of like having a stolen bike. You're still guilty for being in receipt of a stolen bike, even if you didn't know it was stolen. So, and again, commercial use changes the game. People get upset fast. So how do you recognize signs of potential copyright infringement? Well, number one, if you're using a work that's not in the public domain, it's less than 25 years old, doesn't show up in Creative Commons, it may not be yours to use. This is important too. Copying, modifying, using, repurposing, deriving, whatever, a significant portion of your IP from somebody else's IP without the express permission or attribution sometimes is an obvious violation of copyright. So you always want to have explicit permission for a particular use. Specifically, commercial use for purpose, a specific purpose. You might have a license that's good to use it on your website, but not to use it on multiple websites. It might be okay online. It may not be okay for print. Make sure you understand what that particular intellectual property is licensed for you. And folks, I'm going to tell you this once really firmly. March with the mouse. Don't change, modify, don't do anything that you get from Disney. They're a global brand, extremely valuable, and You will get 3-inch thick legal notifications from them at the drop of the hat. Do not mess with Disney. Another one is this, and guys, I know we're not in elementary school, but you just can't steal. Okay, just don't go and copy something and paste it and assume that it's yours and because it was online. It's not. I've had people go and copy forms word for word that somebody else created. That's intellectual property. You can't do that. So, here's some basic steps. Okay, research the copyright status of the materials you want to use. I'm going to show you how to do that here in just a few minutes. But look for the copyright notice on materials, the little C and all that kind of stuff. Search online for copyright status. Drag it onto images.google.com. I'll show you that in a minute. If you have to, contact the provider, outside agents, the broker, the company that sold it to you, the graphic artist that sold it to you, the copyright holder directly. Contact somebody when in doubt. So again, things to check. Is the image free of infringements already? Do you have the proof that you have permission to use it for a specific purpose? Have you gone and checked images.google.com? I love this. The University of Michigan's got a bunch of authoritative, well-cited, well-researched resources for copyright, including a basic guide. Take a look at the website's privacy policy and data policy. If you download something from it, may specifically give you instructions there. Make sure if you're going to use it, reshape it, size it, anything, make sure you have rights to commercial use with modification. And anytime you're using a third party, make sure that they provide you with evidence of proper licensing. Once you get to know a company and they're on the up and up, great. But when you're first getting to know a company and all that, just make sure everything they're giving you is properly licensed. So you've got to be free of infringements, data for proof for specific use, images, guides, website data policy, commercial use with modification, third party right to use. Check those. Now, best practices to avoid infringement. First of all, start with using sources that were intended for you to use. For example, the marketing exchange for travel agents from Outside Agents. And then, of course, EXIF Data is one of my favorite extensions or plugins. I pop in my browser, and what it does is it goes through and reads the metadata that's actually in the image. So there's information they put in there like the author, copyright status, data was taken, picture type. Heck, they can tell you the aperture on the camera when you took the picture. There's all kinds of data in there. I use that for quick research of legitimate images all the time. And then, of course, Creative Commons is probably one of the most misunderstood resources for copyright and intellectual property. But basically, it's a range of licenses that allows users to share and use creative works where the economic benefit is either already realized or it's just been contributed by the creator. This resource here, the library there at the University of Michigan, is outstanding. I would use this. I mean, it's got so much information on copyright, cross-verification, validation. This is a wonderful resource. Take advantage of it. Now, folks, believe it or not, you probably already have intellectual property. You just don't know it. Did you know that everything you've ever written, drawn, doodled, made in Play-Doh is an intellectual property? It's a creation of the mind, right? So it's yours. Sometimes you're going to want to protect it. Not every doodle you make on a cocktail napkin, but let's say your logo or some images that are really important to your branding. What you want to do is establish proof of first use. Okay? Print it out. Mail a copy to yourself. Retain an unopened copy of that mail, including the postmark. That's proof of first use. You can use screenshots. Save them in a folder, encrypt it, in a zip file, so that it can only be opened. When it's opened, the original dates are retained. Of course, you can go that extra step and use that link on the marketing page to take advantage of that 5% discount with Fiverr, or you can hop on LegalZoom and have stuff copyrighted professionally for you. It costs a few $100. Now, speaking of copywriting, the word copyright or the symbol followed by the year of first use and the name of the owner is sufficient to demark an intellectual property as being protected by copyrights. I mean, there's lots of symbols out there. You got, for recordings, trademarks, service marks. No marks required per se, but you want to use them because it wards off poachers, and it just is a quick and easy way to establish not just first use, but continued use. And again, I recommend that you see these guides at the University of Michigan. This is an amazing research tool for most things. Matter of fact, most of the information here was either derived from that website or validated by the content therein. Now, what do you do when you get an infringement notification, a claim against you? Ladies and gentlemen, I am not an attorney. I am not providing legal advice of any kind. All I'm doing is sharing with you the summation of our experiences. And that is that we do not reply immediately to any emailed claim. We talk to our attorney or talk it through with our peers and try to determine if it's legitimate to begin with. Generally, if it comes to you via postal mail, especially certified, it's legitimate. Email ones, generally speaking, not so much. And then if you're in that pickle where, let's say you made a boo-boo and you accidentally copy the wrong image or use it for the wrong purpose or whatever, it is absolutely appropriate to offer less than what they're asking for. Folks, the demands they make are typically 10 to 100 times the value of what they would have sold you that image for to begin with. They're taking advantage of the law, which lets them define the value of that based on your potential to have made money off of it because you're using it for commercial use. Don't do it. Offer them half or less to begin with and let them know you'll pay them today, now, right now. Because remember, the person on the other end of the phone, they're a troll 99% of the time. They're like a debt collector. They'll take whatever they can get. They probably bought that debt anyway. Okay, so just offer them something low and see what they do, but make it explicit when you're talking to them. You're not doing squat until you have a copy of the written release that they propose in exchange for your payment. Then, if something does come up where you license something through a third party, that third party should be able to provide you a copy of their license sufficient to provide to the alleger and get out of the problem altogether. We had a situation with Fodders, F-O-D-O-R-S, and internetbrands.com, who owns them. And Higbee's decided to pick a few images and just start leveraging it. Their stated purpose was to get our agents riled up enough to where we would pay a giant sum. And there was no violation. They just kept on making demands, ignoring our replies, and playing a game. We won. Don't be afraid of Higbee's. And then finally, and this is the absolute last resort, we have errors and omissions insurance. And a few years ago, I added copyright protection to it. Okay, so if there is a violation, ultimately, we're going to be able to help you in some way if it was used in association with our products or is provided by us. Now, if you just grab an image and slap it on your website, that can be a problem. But if it was provided by us, we do have insurance. And if the claim is greater than $1,500, we may bring it in, but we do that as a last resort because as soon as the insurance company sees, Higbee's or the troll sees that there's an insurance involved, they're going to go crazy and start sending notices to everybody. So we want to use that as a last resort. Speaking of trolls, I mentioned them once or 6 times. Look, Higbee's, Pick Rights. My name is Chad Burt. I'm available at extension 210. Call me anytime, guys. I'm tired of your games. Now, I think you know how I feel about them. Read through some of these guides as to whether or not it may be a troll. A lot of times there'll be no specific depiction of the infringing IP, like a picture of the picture they're saying that you took. A lot of times they'll be coming from France or Germany, an attorney over there. They're not taking you to international court over $100 picture. It's not happening. Higbee's, like I said, It's coming from like a Gmail account, so obviously a sign of a big-time attorney, right? High-pressure tactics, okay? Probably not a troll most of the time. I don't reply to any emails about violations. I wait for certified mail personally. I don't ever acknowledge infringement, even if you're dead wrong. Deny all allegations. You did nothing. Say the least possible. Never apologize. And whatever you do not tell them you have an attorney or insurance. Folks, realize this. That paralegal, he's not even an attorney, that's contacting you about this image, if they're a troll, wants to hear that you have an attorney. Because then they're going to begin legal action and the billing will begin. And if you lose, there's a chance you may have to pay for their attorney fee. So they want you to call an attorney and run up that bill until you're out of money and you just give up. They get paid twice. Don't do that. Another thing you should do is contact an expert. You know, we in-house here at Outside Agents, there's no better resources than Dan, Steve, and Dave. Between them, they have over 100 years of experience in everything related to the travel industry, and especially law and copyright. They are an invaluable resource to you. Take advantage of them. Also, be sure to require all communications be in writing via certified postal service. You have that legal right. And then finally, if you're not sure, don't go Facebook it. Don't go Google it. Just call Dan, Steve, or Dave. They can help you. So in summary, 7 key points. You want to trust your gut instinct because you're guilty until proven innocent. Remember that removing infringing content doesn't resolve the complaint. That's like having a stolen bike in your garage. The cop says, hey, that bike's stolen, so you move it outside. You're still in possession of it. You're still responsible for it. So, that means you want to err on the side of caution. Okay, if you're not positive, don't do it. And remember that trolls are everywhere. Know the signs and avoid the fear. The fear is their tool. That's how they win. Don't let them get you riled. And then again, if the claim is legitimate, be humble, air quote apologetic for the hassle, for the time or trouble that they've had to go through. Don't ever apologize for the allegation. I'm sorry for stealing that image. Don't do that. Okay, and always offer to resolve the matter for less than their original demand if they will provide you a written release prior to sending the money. And again, don't let them scare you into paying money you don't owe. Remember that less than 1% of copyright cases ever go to trial. They're a lot bigger than what you're likely to see. And less than 0.3% of that 1% go to claims less than $2,500. And then finally, folks, always do your research and due diligence to avoid problems. And finally, folks, here are those DMO resources I promised you. These are epic. These destination management organizations are there to promote their country. They want you to use their images. They want you to come to them and promote them. Again, confirm licensing, but these are some great resources which are available to you for the taking. Google it. You can find these things all over the place. And if they end in a .gov, .travel, .org, or a country-specific ending like TWJP for Japan, it's probably good stuff. So take advantage of it. So folks, again, copyright's problems are pretty easy to evolve. There's lots of trolls out there. Don't be afraid of them. At the end of the day, know what you're doing. Rely on resources that OutsideAgents.com provides for you. Okay? They're going to be properly licensed and all that. And if there is a problem, we should be able to defend them. If you want to go and use vendors, make sure you're using the right section, the marketing center of their websites. And if you're going to go outside that, we recommend stock.adobe.com or Envato Elements for paid services with awesome images. Ladies and gentlemen, my name is Chad Burt. I'm one of the owners of OutsideAgents.com, and it's been my privilege to be here with you today to talk to you about this very, very important topic of copyright. Folks, it's 1 in 1,000 chance you'll ever encounter it. But if and when you do, you'll be grateful that you were here today. Thanks again.